Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. So today's question is, I'm thinking about declaring bankruptcy. I have a self-managed superannuation fund and it has real estate in there. Is that protected during bankruptcy, or what are the consequences for it during my bankruptcy? Alright, so the starting position is that superannuation, including a self-managed superannuation fund, as long as it's a regulated fund under the Superannuation Industry Supervision Act, or the SIS Act, then it's generally considered protected and the bankrupt can retain it during the bankruptcy as well as after the bankruptcy while it's in that form of being in the superannuation fund. Now, the superannuation fund and an SMSF quite commonly will own real property. So one of the things to watch out for is the transactions or the financial links between the property in that superannuation fund and to some degree the superannuation fund itself as well as the bankrupt. What do I mean? For example, some of the questions around how and when did the property come to be in the self-managed superannuation fund and how was the purchase of that funded? For example, was it funded by the bankrupt making one big lump sum contribution to purchase the property with no mortgage or financing whatsoever very recently, just prior to their bankruptcy? So something like that would definitely be a transaction that the bankruptcy trustee would look at and quite possibly void or reverse, so that property would be at high risk of being lost to the bankrupt estate. Having said that, in the alternate, extreme example, the property could have been purchased by the self-managed superannuation fund from regular contributions that the bankrupt or other members of that superannuation fund may have made regularly over the course of their employment or working life, and out of those funds the property might have been purchased. And at the time of its purchase and at the time of the contributions made by the bankrupt or on behalf of the bankrupt had no concerns in relation to unmanageable debts or any risk or legal action or any sort of indicators that there was going to be some sort of financial problem down the track. In that case, it would be considered that that would be part of the assets of the self-managed superannuation fund, and there are no such concerning links between the bankrupt and the self-managed superannuation fund or the bankrupt and the property. Now, this does get quite complex, and obviously there's quite a range of possible transactions between the two scenarios I've just given there. So if you're not sure, please just ask and we'll try and help you and work it out.